Good afternoon, everyone, and thank you for coming. On Friday, March 7th, I introduced a bill in the House of Assembly entitled the Companies Amendment Act 2014. This bill proposes a number of important changes in the ability of both local and exempt companies to acquire and hold land in Bermuda under the Companies Act 1981. The bill also refers to a new written policy that will guide decision-making for corporate landholding. Earlier today, I tabled this policy in the House. I anticipate that the bill and the associated policy will be debated this coming Friday, March 21st. Now, there are a number of reasons for introducing these changes, and they include, number one, to provide for the first time a clear and transparent written policy on corporate landholding in an otherwise cloudy area of law and practice. Number two, to stimulate turnover in the real estate market and create jobs in the construction sector. And number three, to make Bermuda a more attractive and competitive jurisdiction and to further strengthen the bond that exempt companies and their senior executives have with Bermuda. Over a number of years, the policy, process, and procedures used by the minister to provide consent for companies to hold land has been chopped and changed as a consequence of changes to the Companies Act. These policy changes were apparently not written down, nor was there adequate consultation or consistency in application. This has led to years of confusion and problems in practice. It has also led to some companies being unable to pass on clean ownership title to their property when they wish to sell. The Ministry is aware of at least 10 such cases that have been brought to its attention over the last couple of years. There may be many more, and some companies will not realize there is a problem until they attempt to sell their property. The bill addresses this title issue. If adopted, the minister will be able to provide rectification to situations where, if a company can prove that they should have had proper ministerial consent, they'll be able to receive it. This consent will then put them in a position to pass on clean title to prospective buyers. Another feature that has been missing up until now is a clearly articulated written policy to guide decision-making on ministerial consent for companies to hold land. The bill and policy combined will finally provide written clarity on the law and the process for companies to acquire land in Bermuda. However, I wish to make it very clear that our approach toward corporate landholding is one of caution. Our land is a scarce resource. It is precious. We are very careful to balance this fact with the need to stimulate our economy. With this in mind, we have crafted the policy to ensure that restrictions remain on the capacity of companies to acquire and hold land. The policy is appropriate and robust. The main change between the previous situation and the new policy is that now local and exempt companies will be allowed to purchase residential property. Let me be clear here. The residential properties they will be allowed to purchase are very specific and are the properties that are already available to what is known as restricted persons. This restricted persons category is a designation that the Department of Immigration uses for foreign nationals or persons who do not possess Bermudian status. Residential properties with an annual rental value, or as I sometimes say, ARV, of $177,000 and above are the properties available to restricted persons. There are about 250 high-end residential properties in this category, as well as a number of condominiums that are similarly designated. In addition, the policy will prevent companies from renting these properties in the market. The proposed policy changes will also allow, with certain criteria and restrictions, exempt companies to hold commercial property if it is used for the specific purpose for their business. Similar provisions will apply to local companies. Now, without getting too deeply into the legislative complexities, which we'll do on Friday in the House, I will simply advise that the previous situation was unnecessarily complex and contradictory. That's why we're seeking to clarify it by modifying the law and producing a clear policy. Consultation with the Bermuda Bar Association and the Chamber of Commerce on the proposed amendments has taken place over the past year. It is important to note that these proposed revisions to the Companies Act do not impact on the Bermuda Immigration and Protection Act. The decision-making of the Minister of Home Affairs with regard to immigration consent still applies on landholding. We believe that with the passage of this bill, several properties that are currently on the market will be acquired. This will produce revenue for the government via stamp duty, and, most importantly, this will produce jobs in the construction sector. Many of the properties, once acquired, will undergo renovation and redevelopment. Let me close by saying this is a forward-thinking bill and policy, and one which we believe will move the real estate, construction, and conveyancing sectors in a positive direction. Thank you. Questions?
Questions?
Minister, is there any high profile or high financial property that's up in question, which is why this bill came about? Like, is there anything specific?
Well, as I said, there are a whole series of reasons for doing these amendments, but we have been asked over the last year or so for situations where an exempt company would like to purchase a residential property for their senior manager. And I think that has been one of the reasons that the bill has been brought forward. But as I said earlier, this clarification and having a clear written policy are critically important, and also the problem that evolved over the last 10 years or so, where a number of companies don't have clean title as a consequence of amendments and changes to the Companies Act and the lack of ministerial consent which was provided.